listening to Estate at the Union, estate planning made simple. Here's your host, Brad Wiewel, from Texas Trust Law in Austin, Texas.
Hi, this is Brad Wiewel with Texas Trust Law. This is the Estate of the Union. This is the podcast of Texas Trust Law. We have a variety of things we talk about in our podcasts. We talk about the law a lot, but we also talk about charities, and we talk about movie reviews and all kinds of stuff. But today we have really a great topic, and it's the biggest mistakes that Phillip Arendall has seen as a probate lawyer. Now, who's Phillip Arendall? Well, Phillip Arendall is a fantastic lawyer. He's here at Texas Trust Law. His sole focus here is probate and trust administration. It's when people pass away with a will, you're typically going to do a probate. With a revocable living trust, you may end up with a trust administration. It can be very similar, but substantially different in other respects too. We're not going to go into all that today. That's not our topic. Our topic are mistakes. And Phillip, you're an accomplished estate planning probate lawyer now. Have you seen a few mistakes?
I have. I wrote down kind of the 5 big points that I'd like to go over today, just what I've seen in my time here, and tell a few examples of what, how we learned those lessons and how to avoid them as well.
Great. Before we get to this, I want to take just a minute and focus on people's perception of when I pass away. When I pass away, of course, my vision, I think pretty much everybody's vision is that there is some sort of gathering, maybe a funeral home, maybe a church, synagogue, mosque, wherever, maybe outside in a garden, and people are gathered around and they're very sad about the loss of me, because I'm such a, of course, fantastic person. And well-loved, well-liked, respected in every respect. And they're crying, and what are they going to do without him, and how can we survive? And that's probably a little too much, but we really focus on people missing us and really have that great memory of us. And ladies and gentlemen, this is a whole lot like a football player. And let's take a wide receiver. Now, this is the wide receiver who goes deep down the field, and he's waiting to catch the ball, and the quarterback throws the pass, the perfect pass. And the wide receiver, let's say, catches it on about the 10-yard line, and there's a few defenders around him, and he's running for the goal line, and he sees it, and he spikes the ball. But he spikes the ball in front of the goal line. And we've all seen this happen, and it is horrible. It is horrible. If you don't do the proper estate planning, ladies and gentlemen, you're the player that spikes the ball before the goal line. Phillip has got some great, simple examples of mistakes people have made. Please do the planning so you don't make these mistakes. Let's go, Phillip.
Yeah, and that's a great example, because the will is kind of the pass, and then you're hoping that it gets you across the finish line, but sometimes it doesn't work out that way. And despite people's best intentions, mistakes can be made, and unfortunately they often are. And so the first one that I wanted to talk about is that people don't update their plan when there's major life events that happen in their life. And so we typically recommend people every 7-ish years to really take a look at, from beginning to end, everywhere in between, what do you need to have done again if necessary.
And sometimes the larger the estate, we'll review it every 3 years.
Right. The larger the estate, the more versatile it could be, and every case is a little bit different. But the 2 examples that come to mind, first of all, is a husband, and we just did their probate yesterday, actually.
Wow.
And the husband passed away, and he had a will done in 1982, and then he got married. And in Texas, there's no pre-terminated spouse, which means that the spouse isn't taken care of if a will is made before they get married. And he never did his plan in over 40 years.
So he did a will before he got married, which
Yep.
means the wife wasn't mentioned.
Correct.
All right.
Wife wasn't mentioned. No wife at the time.
Right?
And then he passed away, never leaving anything for his wife. Left a lot for his kids from a prior marriage and his brother's kids, who was our client, but nothing for his wife. Thankfully, we were able to still help him, but that could have been avoided had he just done another will, and he had over 40 years to do it. So
These are really hard cases when they come in, ladies and gentlemen, because you've got the grieving widow
yeah,
expecting to receive all the property,
yeah,
right? And we have the hard job of explaining to her that, again, your husband spiked the ball before the goal line, never did anything, and frankly, we have a responsibility to our loved ones to make sure they keep this stuff going, because they don't want to do this, but nobody thinks about this, do they?
nope.
No.
You don't
No.
want to think about it.
You don't want to think about it, right? And Philip, you've been here for quite a while now, and have you ever seen a line outside of our front door here?
Never.
Never see a line outside of our front door, people lined up clamoring to get in and talk about that. What about, like I've been to restaurants and bakeries where you have to take a number, they call your
Never.
number. Have you ever seen that here?
Never seen that either.
Never seen that here either. Not going to happen, okay? But serious stuff, important stuff. You got another example?
I do, and this one we weren't able to help because we only work with the fiduciary named in the document.
Hold on. What's a fiduciary named in a document?
That would be the named executor,
Okay.
or the trustee if you have a trust.
Okay,
So
great.
sorry for the lingo.
It's okay. I'll help you with that.
But the for this one, we got a call from somebody who, again, was a wife of a husband who passed away, second wife in this matter, and the husband never updated his plan. But in this case, the ex-wife was still named in the will. And so in Texas, not to go into it, but some things happen whenever you get a divorce, and the wife wasn't taken care of again. Very similar situation to the first thing. She was out of luck, basically. So
Wow. So we had two husband examples.
yes, both of them were husbands.
Both of them husbands. He's Stern husband. Your husband?
I am a husband.
I'm a husband too.
Yeah.
Philip actually got married just a
Sunday.
few days ago.
Yep.
So whoever it is, and this
Yeah.
is again, and we'll talk about married folks here, let's talk about single people in a second too, but you're married to somebody, you want to make sure they have a plan, okay? Because it's going to affect you, and it's going to affect you in many respects, and the sound that you're going to hear in the background, in addition to frustration and maybe anger, the sound you're going to hear in the background is cha-ching, 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 okay? This gets way more expensive
It
if
does.
people don't do the planning.
It does. And that's actually what the next mistake is, actually,
Okay,
is when
what's
you
up with
don't
that?
do planning.
Okay.
And so the second big mistake that I've seen is a misunderstanding of intestacy law.
Now, let's do, for our audience here, what's intestacy? What's intestacy law?
So intestacy in Texas is defined generally as the default inheritance rules
Okay.
for everybody. You, me, the listeners. When you don't have a will, the state of Texas has laws that says this is what happens.
They've kind of written your will for you.
In a manner of speaking, yes.
Yeah.
That's
Okay.
exactly right. And so a lot of people just think it goes to where they want it to go. But wouldn't that be nice?
Yeah,
if
wouldn't
the,
it be nice?
If the state of Texas just knew what you wanted to happen and then it happened.
ESP's a little weak
Yes.
in that respect.
But that is not the case. Fortunately, unfortunately, I guess it depends on your family situation. But a general misunderstanding is just trusting kind of the assumption that it just goes where you think it's going to go, and that is not always the case. The example that I have is a man who we were hired for his case. His wife suddenly passed away, and they didn't have a will. And the husband assumed that he would receive everything. but the wife had inherited mineral rights from her father. And so that was considered separate real property, and that was split between his wife's mother and brother, who was also alive.
But not him.
But not him. And so the family dynamic wasn't great. They contested his involvement in the probate. We ended up not being able to take the case because it would have been a contested probate, something that could have been avoided had they done a simple will.
And we don't do contested probates.
Right.
We don't do litigation.
Do
right.
So,
we have litigators who we refer people out to,
yeah.
but we don't do them because it's just so hard and it's just so stressful, and frankly, it gets really ugly. Wow. And let's just jump up on that because the point you made is an excellent point, Philip. I think the greatest misunderstanding that people have is that if, and particularly in a marriage situation, if I'm married, I get it all.
Right.
My spouse dies, and it is far from the truth. And particularly, you gave a great example, which is a little more of an obscure example of separate property, and that's going to go back to the family, perhaps the deceased. But what really happens more frequently is that the spouse who died had children from a previous relationship.
Yes. A blended family can greatly disrupt what you normally think would happen when you die, so to speak. My family's a great example of that. I have a very blended family. My mom and dad both had kids from a prior marriage, and my dad passed away when I was 23, and thankfully he had a will, but if he didn't, then the whole inheritance structure would have been completely disrupted than what you would have thought.
What would have happened is that Philip's mother would have been able to keep her half of the community property, but his father's half
would have gone to my oldest brother, who probably would have tried to give it back to my mom because he loves her, but not all families are like that either. And
so if you die without a will and the deceased had children from a prior relationship, the deceased half of the money goes to their children, not to their spouse. And so it would have been your brother and you, because you were your father's child too. And it's horrible. Again, this may be a large estates, there's plenty of money to go around, but usually they're not large estates, and so there's not a lot of money to go around. And maybe now your mom would have owned the house with your brother, who he did love your mother, but that's of course not always the case.
Right.
A lot of people don't like their stepmother, like their stepfather, and now you're stuck.
Right. You're stuck hoping that they're amenable to maybe you buying it, or hopefully them giving it to you.
Or just leaving you alone.
Or leaving you alone, yep.
Yeah. So we don't want to counter that, okay? But the point you made, excellent point, your dad did have a will.
He did have a will.
It left it to your mother, worked well, end of story.
Yep.
Okay, all right. Now, Philip did an excellent job, ladies and gentlemen, preparing notes on this with great examples. And I'm looking at one here, Philip, that I reviewed earlier, but I want you to take a little time and help with the cat story.
Yes.
We have two cat stories?
There are two cat
All
stories.
right, let's talk about cats.
There's a right way of doing the cat story, and there's a wrong way of doing the cat
Okay,
story.
let's hit, do you want to hit wrong or right first?
Let's do the right way first.
Okay, that's good.
'cause then
He's such a good guy. I would go wrong, but he's going to go right.
And so this is the third biggest mistake, which is giving gifts to ineligible beneficiaries. And so the right way of giving a gift to a cat or dog or any otherwise ineligible beneficiary,
right, like an animal,
is to give it to the caretaker of the animal. And so, and the right way, we had a will where the will first said the caretaker is person A, and then gift to caretaker, assuming they take care of the cat.
A fluffy.
Right. Mooney, I think, was the name of the cat.
Okay, great. Mooney, yeah, that's right. You got it in your notes there, Mooney.
And so that was the right way of doing it. They first established the caretaker, and then they made a gift to the caretaker.
And a lot of times we'll leave money to the caretaker for taking the responsibility because they're being nice. Plus, animals can be expensive too.
They can be. They can be, absolutely.
There's also a thing in Texas law called a pet trust, and you can set that up in a will or revocable living trust that acts the same way. This is a little simpler here, and it was a great result.
Yeah.
Okay.
Yep.
Now, what about the wrong way?
So the wrong way was a phone call that was not all surprising to the named executor in the
Okay,
will, who I was
okay.
on the phone with. And this was kind of a train wreck of a phone call, but the person who passed away, in an effort to take care of his cat, he left 10% of his estate to his cat. And animals are personal property, and you can't leave property to property. And so
Right, and cats can't, they're not good at check writing, they're not
they
good
can
at...
scratch it, but they can't cash it.
Scratch it, not cash it. Okay, good,
And
I like that, I like that.
They, invalid gift. And so the other thing was, this is a do-it-yourself will, and there's kind of like this doomsday provision, if that gift fails, what happens next? That was completely blank.
Mooney was dead, too. Was Mooney, was
I
the
think
cat
Mooney
dead?
was alive.
Oh, Mooney was alive, all
And
right,
so,
all right.
not that it matters,
It
'cause
doesn't matter.
cat can't receive it anyway.
And so it's some of this doomsday provision. And of course, we put those in all our wills and all our revoked living trusts. That's a provision that Philip just alluded to that says, well, what if there's nobody?
Right.
It's kind of the doomsday provision since the whole family's gone.
Yeah.
And where does it go then? And of course, he didn't include that because he did his own thing.
Right.
Which
Did his
means
own
now, where does it go?
To his heirs, and who are those people?
Who the heck knows?
We'll find out when the state of Texas and many, many thousands of dollars later determine that.
Wow.
So,
Wow. So, again, you can avoid all these things. You can avoid all these things by just doing planning with a qualified, experienced state planning attorney who can help you through these things and knows the questions to ask and can help you give an answer that you need to hear, so that if we leave money to Mooney the cat, the money goes to somebody who can actually care for Mooney, which is the point, right?
right.
And
That was ultimately his intent. He
Right.
just didn't know how to do it.
now, I'm old enough to remember, and some of our listeners and viewers may be able to remember, Leona Helmsley. And she was a very rich, wealthy woman in New York City. And she left, I'm going to say $10 million to her dog. And the dog's name was Trouble.
Okay.
Her dog's name was Trouble, and it became this huge controversy. So, we love pets. I have pets. You had a dog, and
I did.
yeah, probably get another one soon. And they're great. But
Yeah.
if you want to take care of your pets, you've got to do it carefully. I think we have a previous podcast with Melissa Donovan here. We were talking about pet planning too. So you want to check that out earlier, season or two back. Let's go to the next mistake you've got.
Yes, the next one is one that we see pretty often from wills that are created usually by employers, not by attorneys, and that is the incorrect execution of the will itself. And so relying on the advice of notaries, which is pretty common. Many people in our office are notaries,
Sure.
but that doesn't necessarily mean that you understand Texas estate law.
There's a difference in a notary who's not a lawyer, and of course a notary who is a lawyer.
Right.
And particularly, again, an estate planning lawyer.
Exactly,
Right.
right. And so one of the things that we see a lot is people coming in, somebody has passed away, they named me the beneficiary in a will. Surprise, it was never actually completed. It was never actually executed
Right.
correctly. And so the example I have for this was a cousin called. She came in with her husband, and her cousin passed away here in town. She's from out of town. He had a home in Jarrell, which is north of Austin, kind of a bit up north.
Right, it's a boomtown now, though, between Georgetown and Temple.
Yes.
Right.
And cousin, the one who passed away, left his house and this fill-in-the-blank will pamphlet from his work to the woman who came in. Well, he never signed it. He never had two witnesses over the age of 14 who were disinterested sign it, witness his signature, and sign it also. So it was just a pamphlet with his well-intentions
man.
on it. And similar to the Mooney, to the cat example, that house went to his heirs because there was no valid will.
Not to the cousin who was sitting in front of us.
Right. And
Right.
she was bewildered by that because it was clear that her cousin wanted her to receive that
Right.
house.
Right.
But there's no valid legal instrument to ensure that his wishes were made and followed.
So the problem with either do-it-yourself wills, computer-generated wills, I'll say this, a legal Zoom will, for goodness sakes, it's not, it is a lot about what it says, of course, but it's how it's signed.
Right.
And Philip just went through a little thing, which you may not have caught, class, but he said the witness over 14. Witnesses to a will must be over 14 years old.
Yeah.
They must be of sound mind.
Disinterested.
Right.
They can't
they're
be
not in error,
beneficiaries.
right?
Yeah.
Yep. So little things like that. Did you know that?
I was at church the other day, and a friend that I used to serve in students with, he came up and he had something his employer gave him too, and he said, hey, I went to a notary to get this signed and they wouldn't sign it. And I was like, well, I don't know why the notary didn't let you, but he said, yeah, my parents were there and his parents were beneficiaries in the will. And I said,
Right.
well, it's a good thing they didn't sign it, because you would have thought this thing was just squared away, but those are not valid witnesses.
And people sometimes just get it notarized
Yep.
and think they're done. And that
Yep.
doesn't cut it either. So this is complex stuff. We're dealing with your life's work. You're dealing with your life savings. We're dealing with a home you may have, which is probably in this area worth $300,000, $400,000, $800,000. We're dealing with vehicles that are expensive. We're dealing with money in banks, and again, this is everything you've got left. And some people think, well, gosh, for $35, I can do my own will.
Yeah.
Again, don't spike the ball before the goal line. All right, now let's go to, one more example of mistakes.
One more example of a mistake, and this one is just generally, we already kind of talked about it a little bit, and that's just the general DIY estate plan. We talked about that kind of combining both of these
We did.
topics, but there's so many examples that we have of DIY wills gone wrong. And the one that I want to talk about is a very smart man, very successful engineer who, we love engineers.
We do like engineers.
My wife is an engineer, so I love her very much. And she is very smart. But this person in particular, they hand wrote their will for himself and his wife.
Right.
And so it was a joint holographic will, which I never even heard of that before, and there's a reason why, because it's not valid.
A holographic will means it's handwritten.
Handwritten.
Handwritten wills can be valid, but
Yep.
they will always have problems with them.
They do, and they require a more complicated administration because you have to have somebody who can verify that that actually was your handwriting. And so if you have chicken scratch handwriting, which I kind of do sometimes, that might be a little bit more complicated to do. It's easier to just get something official done, no questions asked.
Right.
So, but in this situation, he did it for his wife. And a holographic will has to be wholly in the testator's handwriting.
The testator is the person who died
Right. So
Right.
the husband had a valid will
because he wrote it.
because he wrote it, but the wife did not because she did not write it.
Did she sign it?
She did sign it.
But
Doesn't
it wasn't
matter.
her handwriting.
Wasn't her handwriting.
Wow.
And there was even a clause in the will that said, if any of these provisions fail, let common sense prevail.
Oh.
And it's just like,
And that makes so much sense. And again, I'm sorry, I giggled at that, but the law is not, we all would think
It's
it's
not forgiving.
commonsensical, don't we?
yeah.
And gosh, it should be this way, and I've heard that it's this way. And
Right.
we deal sometimes here, ladies and gentlemen, what I like to call coffee shop and beauty shop rules. Where the older guys sit around with their buddies and drink coffee in the morning, the ladies go to the salon, they get their nails done, their hair done, whatever. And they're talking to somebody, and this is how my cousin did it, and my third cousin twice removed did it, and this is how you should do it, because this is how it works, and it's not.
And thankfully, we were still able to help him,
Okay.
and we were still able to help her too, because both of them had passed away at that point. So she technically passed away without a will, and it went to her heirs. She passed away first. Technically, he was her heir, so it went to his estate and then to the kids.
Right.
But it wouldn't It doesn't always work like that.
It doesn't work that way in blended families particularly.
Yeah.
Whoa. Well,
Yeah.
how about that?
Yeah.
You know, we all make mistakes. And some mistakes are bigger than others. Some you can overcome. I like to tell folks who come into the planning, as long as you're vertical, we can help you.
Right.
When you go horizontal, it just gets a whole lot harder. So these are great examples, Philip, of mistakes people make. Again, we picture our funeral service and, again, the mourning and the weeping and the crying and the loss. But, again, that can easily go to anger.
Yeah. It can.
It can, and we don't want that. You don't want that. So are the people who are dealing with your affairs don't want it and don't need it. And frankly, they have other things to do with their life too, and now they get stuck dealing with us,
Right.
doing things that, again, expensive and frustrating and shouldn't have happened. So we at Texas Trust Law offer a free consultation, and you can come in and see us to talk about doing a will, doing a trust, doing other things. If you have somebody who's passed away, Philip and Ann Lumley are our afterlife care team, and we can help you with that. We do lots of afterlife care stuff, probates again, and trust administration and things like that. Sometimes there's some shortcuts we can do that it can be very inexpensive, but very effective. Other times we get other things we have to deal with. So please avail yourself to a free consultation here at Texas Trust Law. Our website's texastrustlaw.com. Our phone number is 512-480-8828. We have offices all around Central Texas. We'd love to see you. And if you come, if you're married, you have to bring your spouse because we want you both on the same page. But we'll help you. And we'd like to help you too. We're going to stop right here. Philip, thanks. What a nice presentation. This is really, really good. And hopefully you enjoyed it too.
I did. Yeah.
We'll be back for another edition of the State of the Union soon. Have a great day.
Thank you.